As you've read in Chapter 2, there's 4 sources of the law. Those 4 sources are constitutional law, statutory law, administrative law, and common law. When we talk about constitutional law, we're really talking about the principles and rules contained in either the U.S. Constitution or in the states' constitutions. Our U.S. Constitution, believe it or not, is the first written constitution of any nation, and it provides the framework upon which all our laws are made. There's 2 functions for our U.S. Constitution. One is to organize government power, and the other is to protect our individual rights. When we use the phrase separation of powers, what we really mean is that the drafters of the document were careful not to put all the power of the government into one place. So instead, they separated power into 3 different places. One is the legislative branch, which we know as Congress and the House of Representatives. They make the laws. Or the executive branch, which we know as the president, he enforces the laws. And the third is the judicial branch, which interprets the laws. Each of these divisions has the power to keep the other one in check. And that's what we call the system of checks and balances. For example, although Congress has the power to make the laws, the president, the executive branch, has the power to veto them. The second function, protecting individual rights, is done through the first 10 amendments, which we commonly know as the Bill of Rights. Included here are freedom of speech, freedom of press, freedom of religion, the right to an attorney, and so forth. Along with the 13th, 14th, and 15th Amendments, they serve to prevent state or federal government officials from interfering with our civil rights and liberties. In Module 7, we'll be taking an even greater detailed look of the United States Constitution. The Constitution also divides government power between the national government and the state government, and we call that federalism. So authority is split between a single nationwide central government and several regional governments that control specific geographic areas. Each of the 50 states also has a written constitution that defines the organization and power of the government. Most also include equivalent of the Federal Bill of Rights. In the past, many attorneys tended to ignore their own state's constitutional processes. Recently, however, there's been an increase in litigation based on state constitutions. This is partly because many state constitutions provide an even greater protection of individual rights than does the federal Constitution. The second source of law is statutory law. Even though the federal and state constitutions outline broad guidelines within which the government must operate, they were not designed to contain the types of detailed laws that we need in today's complex society. So the federal and state constitutions delegate that power to make laws to the legislative branches of the government. Congress makes federal laws, state legislatures make state laws, and cities and villages enact ordinances. Statutes and ordinances lay down general rules that govern future conduct. They're general in the sense that they apply to broad categories of people rather than to specific individuals. Furthermore, the requirements they impose generally cannot be applied to actions taken before the law went into effect. The third source is administrative law. And I'm sure that you are very familiar with many of the administrative agencies we have in our country. For example, we have the Equal Employment Opportunity Commission. We have the Security and Exchange Commission. We have Federal Administration Federal Aviation Administration, and many others. Assume, for example, that you buy a winning lottery ticket today for $1 million. Do you have to pay taxes on your winnings? Well, the Internal Revenue Service, which is a federal administrative agency, has special regulations that can answer those questions for you. Our last source of law is the common law, and this is law that's created by the courts. Because we're a common law country, judges look to decisions that were written before the case was decided, and they try to follow the same reasoning. This is referred to as precedence. The doctrine of stare decisis means to follow the rules laid down in prior decisions.